Good morning. Thank you very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matters before the court this morning are the consolidated cases entitled Office of the Auditor of Accounts et al. Versus Office of the Attorney General et al. Case numbers 24 AP 403 and 25 AP 022. Each side has 25 minutes for oral argument. Representing the appellant, Vermont Office of the Auditor of Accounts, is Attorney Matt Byrne. Representing the appellee, Vermont Office of the Attorney General, is Attorney John Rose. Seated at counsel table with Attorney Rose is Attorney Sarah London.
Thank you very much. Good morning, counsel. Thank you for being here. We'll hear from counsel for the appellant first. Please come on up and for the record, introduce yourself and your client and then proceed.
Thank you, Your Honor. May it please the court, I'm Matthew Byrne, representing the Office of the Auditor of Accounts.
Thank you.
Right now, the Office of the Auditor cannot do its job. The Attorney General has said that it will no longer respond to any requests for legal advice from the auditor. The Attorney General has also taken the position that the auditor cannot challenge that position in court. Those decisions cannot stand. The Office of the Auditor is a constitutional yes.
Thank you, Mr. Byrne. So you begin your oral argument about the inability of the auditor to be able to complete audits because of the refusal of the Attorney General to provide advice to you. So I just want to go back to the appellate volume, if you can just clarify this for me. You cited the file that was, I'm sorry, let me just go back. You provided the trial court after the hearing, but before the court issued its decision, a file that states on its face, questions were not submitted to the AG. That's at appellate volume 151. Describing that file, your reply brief states that the AG failed to provide legal opinions. So help me understand which it is. Is it, did the auditor submit those questions to the Attorney General and then got no answer? Or did the auditor decline to submit those questions to the Attorney General?
The way that the auditor thinks of it is, if you take a look at paragraphs 16 and 17 of the complaint, they had a meeting with the Attorney General where he was president and Mr. Timothy Ash were president. And they said, we're not giving you any more opinions. So from that point forward, they didn't have any ability to submit requests to the Attorney General for opinions.
So, Mr. Byrne, that still is not answering my question. My question is very specific. The file states on its face, the questions are not submitted to the Attorney General. Were those questions submitted to the Attorney General?
My understanding from the memo that was part of the affidavit is that the questions weren't submitted.
They weren't submitted?
They were not submitted.
Okay, thank you.
But so to complete the thought, what happened was that they had a meeting where the Attorney General told them that they would no longer submit, would no longer respond to any questions. And so the auditor felt it was a futile act to do so. So the Office of the Auditor is a constitutional office with constitutional powers, and it performs an essential function for Vermont's democracy. It plays a key role in trying to root out fraud, waste, and abuse. And as this court noted the importance in the OneCare case, but the issue with the OneCare case is that the Auditor of Accounts was said to solely have statutory powers. Once that ruling was made, a number of different one of the offices of state government, DEVA, has now taken a much broader position and won't respond to requests from the Auditor of Accounts, so that there's significant problems with the workability of the Auditor's Office of the Opinion in the OneCare. The other issue with the OneCare case is that this court unfortunately did not have all of the evidence that it needed to make a decision about the constitutional powers of the audit. In the briefs, there were no information related to the constitutional arguments that the auditor is making here today. And so this court didn't have an opportunity to weigh that information when it made its decision in the OneCare case. Turning to the statutory arguments and the TIF-related arguments, Section 159 says that the Attorney General shall advise the elective and appointive offices on questions of law related to their official duties and shall furnish a written opinion on such matters when so requested. The language of the statute is shall, and it is mandatory. So the AG has no discretion about whether to issue an opinion. The AG has admitted that the auditor has requested an Attorney General opinion relating to 3 questions of law regarding tax increment financing. And the Attorney General has conceded that it has not answered those the first 2 questions.
But I read lengthy letters that she sent to the auditor, and I understand as well that the auditor used some of the information in that one of those letters in an audit at issue here. And so if it wasn't advice, I don't know why it would be included in the audit that was eventually sent out.
Well, so that information related to the 3rd question. It didn't relate to the first 2 questions. The Attorney General said in the letter, quote, "We decline to opine on the interpretation of provisions of Title 24 requested above." That's at the printed case 55. It's also alleged in our complaint at printed case 29, paragraph 19. So they said, we're not going to answer these questions.
But then there was how many single space pages that followed that? I mean, she explained why she wasn't answering the questions because other groups in Vermont are the ones that make those decisions about that TIF issue. And so isn't that advice to the auditor that, look, this isn't something the AG is ready or should be opining on. You should go to the sources, those people who manage this program. Isn't that advice?
No, I don't believe it's not an answer to the question, right? The statute says that they shall answer the questions of law and shall furnish a written opinion on such matters. So there is no response to the question of law. There is no answer to the first 2 questions. So the auditor is left without any way of obtaining interpretations on those particular TIF statutes.
Can I interject a question here? How would you define the difference between a question of law and a question of policy?
So a question of law is one that asks, for an interpretation of a statute or something like that. A question of policy is, should we do a certain thing or not do a certain thing? The auditor is charged with providing what's known as governmental auditing. And one of the things that the Vermont statute charges it to do is specifically 5504 AL says that the Attorney General has to let the Secretary know whether there's been compliance with the sections of the TIF law. So it says audits shall conducted pursuant to this subsection shall include a review of the municipality's adherence to the relevant statutes and rules adopted by the Vermont Economic Policy Progress Council pursuant to subsection J of the section. So the legislature has charged the auditor with doing that and giving, saying whether they're complying. The legislature has also said that under GAGAS, the Attorney General, the Auditor of Accounts can't do that themselves. They have to go to outside people to get those opinions. And the only official way that the auditor can get that opinion is through Section 159, because the legislature has established the Attorney General as the only source of legal opinion for officers of the state of Vermont.
But didn't the Attorney General at the hearing on the motion to dismiss, I think it's on page 5 of the transcript, agree that she has an obligation under 3 VSA 159 to advise the auditor.
Correct, but they haven't done that. They
Well,
haven't- I'm sorry, go ahead.
no, that's right. That's fine, Mr. Byrne.
Yeah, but they haven't responded, and they admit that they haven't done it, right? They said we declined to opine on those questions. And so that's never occurred. Questions 1 and 2 have not been answered. There is no answer to those questions.
Well, isn't that a discretionary decision then?
No.
For her to consider what was posed to her and say, I decline to answer these questions for these reasons? Isn't that an act of discretion that would prohibit mandamus, seeking mandamus?
There's 2 questions in there. One is a discretionary act, and the answer is no. The legislature has said they shall do that. Therefore, it's not discretionary, right? They have to answer those questions of law. It's right in section 159. The question of mandamus, the point that I made to the court is it doesn't have to go as far as mandamus. It only needs to go to a declaratory judgment and say, you need to respond to these questions of law and provide an answer to them. So it's not the discretion piece is, it's not how they do it, but whether they do it. And they've admitted that they haven't done it. So once they've admitted that they haven't done it, then this court says, no, you actually have to do what the statute tells you you're supposed to do, which is to respond to these questions of law.
I guess it's just probably a difference of the interpretation than of the response of the Attorney General, because the response is, I would directing the auditor to the entities with statutory authority to make the binding decisions on the question rather than to herself, whose opinion would then only be advisory. Is that not giving advice? I mean, you're under the statute, the Attorney General has to advise or give advice, but doesn't mean you have to like it, right? And maybe that's the issue here. Maybe the auditor doesn't like the response, but I don't see that as a complete refusal on the part of the Attorney General to meet her obligations under 3 VSA 159.
The auditor has no issue with the advice, right? Or whatever's been given. It just doesn't have an answer, right? It cannot complete the audit that it is set out to do, which it is charged by the legislature with doing. It can't answer, it cannot complete the audit.
But those audits, and I asked you this, Mr. Byrne, at the beginning of oral argument, those audits referred, there were questions that referred to those audits. And I asked whether, and maybe it's a different issue, but I asked whether those questions had been submitted to the Attorney General. And I believe your answer was they had not been.
So this is an important point. There are 3 audits where they didn't submit the questions. There is 1 audit where they did submit the questions. And in the report that relates to that audit at pages 13 through 15 of the report, they noted that they have not gotten an opinion and that audit, the audit of the Burlington TIF District, is incomplete. They cannot finish that audit without the answers from the Attorney General.
So the TIF audit is then separate from the audits that you allege in your complaint that are what, the Dale and ACCD, DVHA, is that
Yes,
correct?
there's 4 total audits.
Okay.
Those 3 that you were talking about are audits that occurred after the Burlington TIF District.
And those questions were not submitted to the Attorney General as to those 3?
Correct, Your Honor.
Okay, it's just the TIF. You're just talking about the TIF.
The TIF,
Okay.
the TIF one, the questions were submitted, which are the 4 different letters that went back and forth between the Attorney General and the auditor. And they have admitted, right, in their own letters and in their statements to the court, and the Superior Court recognized that, right? The Superior Court said, to be clear, they've admitted that they have not responded to these questions, right, in the November 1st and November 21st issue. So there's certainly an incomplete audit for the Burlington TIF District. Well, there's 4 incomplete audits. There's an incomplete audit where the questions were actually submitted and they did not obtain answers to that. I mean, the analogy that we use is the law clerk, if you ask them to write an opinion about subject matter jurisdiction and they came back and told you an opinion about personal jurisdiction, that's not going to be useful to you in your job, which is why Section 159 is set up the way it is. right? If an officer has a question that they need to have answered to do their duty, then the answer has to help them complete their duties. If the opinion has nothing to do with what they need to do under the statute, then it's not compliant with Section 159. And they've admitted that, right? Questions 1 and 2 have not been answered, and the Superior Court recognized. But if the court goes and says that there is no duty under Section 159, the auditor still has to do its job. Then I think you reach the constitutional question, which is, does the auditor have the power to audit and implied powers that go beyond what Section 159 has? So if the auditor can't get a complete answer from the Attorney General to complete its duty, it still needs to go out and get a legal opinion. And to get that legal opinion, I think that this court needs to recognize both the express power to audit and the implied power to get counsel to complete its job. So if this court is not going to say that the Attorney General has to complete the audit or answer the questions under Section 159, then I think the question is squarely presented that does the auditor of accounts have the express power to audit and the applied power to hire counsel necessary to complete its job? And on that issue, there's really no dispute in this court. There's been almost no argument on the other side related to the constitutional issues in this case, which were not squarely presented to this court in the OneCare case, in which the court didn't have the information about the history of the office of the auditor, the statutory provision that's relevant, right? The whole section that actually says, the word audit in the Vermont Constitution was not even before this court when the court looked at the OneCare case, nor were any of the structural arguments or the textual arguments or arguments about the social and economic importance of the auditor in the constitutional system for Vermont state
Mr.
government.
Byrne, how much weight should we give to the historical content as to whether or not this is constitutional or statutory?
Well, I think in interpreting the Constitution in this particular case, you should give a great deal of weight to the history.
And the history being what? Some of the books that have been written, some of the stories that have been told? I mean, the question I have about that is, it's never been subject to cross-examination. Somebody who testifies to, this is the historical content with the censors and how they applied the role of the auditor back when Ira Allen was part of the state.
Well, a lot of those are official government records that we cited, right? These are official government records. So from an if you're talking like an evidentiary standpoint, it's subject to judicial notice by this court. But more importantly, the history there is very rich about the importance of having an auditor look at governmental functions, because there was a real concern that Ira Allen was in fact ripping off the state of Vermont when he was serving in 2 different roles as both the treasurer and the surveyor general. So the history there, I've reserved 7 minutes for rebuttal, but the history there to me is very important in looking at the meaning of audit in the Vermont Constitution.
So, Mr. Byrne, if we were to agree with you that the auditor has the constitutional power to audit, what are the limits on that power?
So we went through a number of those. The first is that the plain text of audit is just to sort of check information. So inherently in that power, it's very limited. But the other checks are that the auditor doesn't have any of the other powers that the other branches of government have, right? It doesn't have the ability to appropriate. It doesn't have the ability to enforce the laws, and it doesn't have the ability to decide cases, right? The auditor's opinions are just information that both the people and the General Assembly can look at to make decisions about how they want to run their democracy. I mean, one of the issues with the administrative state is that it's very complex and that people can't get information about the administrative state. So it's very important that you have somebody who has sort of a technical expertise help the government, the General Assembly, and the people understand what's actually going on in all of these agencies.
And would your argument about the inherent power of the constitutional officer then apply to all other officers in the state? The Vermont Constitution?
I don't know. I haven't researched the other particular offices, and I haven't looked at the history of each of those offices, which I think is really important in the auditor case. But there are precedents that show that there are implied powers. right? The Dean v. Bates case has already said that the Secretary of State has the implied power to hire its own counsel. And the Grout versus Gates case also said, that they have the authority to be sued and to retain their own counsel, to pay their own counsel. So there is precedent for doing that in the past, and I think this court should continue with that and extend that to the Office of the Auditor of Accounts. Thank you.
Okay, thank you. We'll hear from counsel for the appellee, please. Come on up and before you start, please, for the record, introduce yourself and your client.
Good morning, Your Honors. May it please the court. I'm John Rose, appearing on behalf of the Office of the Attorney General.
Thank you.
So I think all the parties have agreed that this case is unusual, but I don't think it necessarily has to be as complex as the briefing suggests. The auditor raised essentially a single count against the Attorney General, and that's the Rule 75 mandamus claim. And I'd like to start with that claim before addressing some of the other issues that the auditor has raised. So the mandamus claim, as the court recognized, is based on an exchange of correspondence found at pages 41 to 64 of the printed case, in which the auditor asked the Attorney General essentially three questions related to tax increment financing and how it applied in that case to the city of Burlington. So the Attorney General responded to those questions by giving the auditor legal advice, and that legal advice was that the first two questions you've asked have to do with how bond premium should be treated under that statute's definition of financing. There was no clear answer in the statute, and yet, and in addition, the statute set out a process for clarifying policy issues like that under TIF law. The process involves rulemaking at the Vermont Economic Progress Council. It involves informal advice provided by VEPSI under its own rules, and it provides a formal adjudicative process at the Agency of Commerce and Community Development. And given those factors, the Attorney General's opinion to the auditor was that if there's an ambiguity in how TIF law applies as a matter of policy to a municipality, not about the auditor's duties under TIF law, that that question should be addressed by statute to the administrative agencies responsible for implementing TIF law. And these really were policy questions. The kind of questions that if the Attorney General had offered an opinion, it wouldn't be binding. There would be no deference to the Attorney General from this court. This is like any other administrative agency's regulations where there's an ambiguity in a statute. An agency has the expertise to fill in that ambiguity based on what the policy of the state should be. And the agency issues regulations, or at least goes through an adjudicative process within the agency where there would be some deference and a binding opinion at the end of the process. And that's the problem that the Attorney General saw in the limited practice in the past of issuing opinions on issues like this. The Attorney General did offer an opinion on the third question, which anticipated the Attorney General's response to the first two questions. The third question was whether VEPSI had rulemaking authority to address the first two questions, and the Attorney General answered that question in the affirmative, consistent with the probably over 10 pages of advice that she provided on the issues generally. So we think that fell well within her discretion to provide legal advice, and any opinion from this court on mandamus finding that decision wasn't within her discretion would be a serious intrusion on the Attorney General's function in the executive branch to be the advisor to state government on legal issues. So once that relatively simple question is decided, I think the rest of the case goes away.
So, Mr. Rose, let me ask you then, if the auditor can't seek mandamus, right? Then how can the provisions of 3 VSA 159 be enforced?
So I guess I'd make a couple of points in response to that, Justice Waples. The first is this is a pretty complicated area of intergovernmental relations. We have 2 elected officials. If we allowed one elected official to sue the other one every time the first one thought the second one wasn't doing their job properly, that wouldn't be a very efficient recipe for government. And there's nothing in the text of the statute or the Constitution that contemplates such lawsuits. The second point is that the Attorney General is not without constraints in this situation. The first, as I mentioned, is political. If the Attorney General is not doing her job, she'll presumably be held accountable for that through the political process. And we have 2 very sort of highly sophisticated political actors here that can operate within that space. And we don't think it would be appropriate for the court to interfere in in that relationship. The second is the Attorney General is an attorney subject to ethical requirements. If the office is not following statutes blatantly, there could be ethics consequences that would be enforceable. There are other state officers, as we pointed out in our brief, that do have the authority to file litigation and that could take up the matter in some way or another. And as a final backdrop, the governor can appoint a special counsel if the governor is convinced that the Attorney General is not doing her job to investigate the Attorney General. But we don't think this case comes anywhere close to that because the Attorney General simply did what attorneys do, which is offer legal advice to a client.
And what do you think that this court should do relative to the argument that there's a blanket refusal by the Attorney General to give legal advice as requested by the auditor in the future?
We think that's incorrect and contradicted by the record. So if you look at the back and forth in the printed case, again at printed case pages 41 to 64, the Attorney General never said that she would not give legal advice to the auditor. The Attorney General's response was limited to TIF policy issues, which fall under the rationale that those issues should be more appropriately addressed at the administrative agency responsible for them. The Attorney General never said she would stop providing legal advice to the auditor.
So-
Even in the realm of TIF, if the question were to come up about the auditor's authority to do something under TIF, I presume that the Attorney General would advise on that.
So is it a question of law or fact whether or not the Attorney General gave legal advice?
It's a complicated question, Your Honor, I suppose, and it's a hard one to define, but I don't think the definition is particularly important in this
Not
case.
important.
The question arises under the mandamus, principles of mandamus. So whether there's a discretionary duty here, I think falls under the question of law category. And I think the court could answer the question as a question of law as to whether the Attorney General gave legal advice within the discretion afforded by the statute. And I think the discretion, we've cited the case from Arizona, the yes on Prop 20 or 200, I can't remember which makes clear that courts should be very, very deferential to legal advisors in government when deciding mandamus issues because of the potential for the court to become a second level of review for legal advice. The court doesn't want to be the legal advisor to the government. The court decides legal issues.
Just to follow up on my earlier question.
Yes, Your
you agree that there are situations and circumstances where the Attorney General is obligated to provide legal advice to the auditor?
Yes, again, we think she did so here, of course. But if the Attorney General had just said, no, I'm not taking your calls, or I'm refusing to engage in this question at all, then we might have a much tougher case. And again, there would be constraints on her ability to do that, both as a politician, as a lawyer, and as a member of the executive branch.
Well, their position is that there came a point in time when the Attorney General said, I'm not going to give you advice. Am I right?
I'm not aware of that happening. I wasn't in the meetings.
No meeting?
But the meeting took place in April of 2023. And the correspondence that followed up, which is the correspondence in the printed case, took place in September 2023. And so it's clear from the record that we have here what the Attorney General's advice to the auditor was, and it was not that we're never going to answer another legal question. I think that's unreasonable on its face, and I'm certainly not aware of any representation by the Attorney General to that effect.
Can you speak a little bit about the right to sue the AG?
Sure. I think our first point on that, Justice Carroll, is that the court doesn't need to decide that issue in this case because the auditor retained a lawyer, brought suit twice against the Attorney General, and got a merits ruling on the legal claim that he brought. And so there's no live controversy over that issue. And so the court could resolve the issue on that basis, that the issue is simply moot at this point. The second point is that, again, the history that we've outlined in our brief shows that for hundreds of years, I guess, the auditor's duties have been defined by statute. And the auditor is saying here, no, I have this broader constitutional right to sue. And we think the court should be very cautious about implying that right into the auditor's constitutional functions without any sort of legislative or further constitutional definition for a couple of reasons. Excuse me. And I think the first is, again, as I said, the legislature has, first of all, this court has held just 3 years ago that the legislature's powers are defined by statute. That holding was based on a 1904 case that also said the legislature's powers are defined by statute. And that's consistent with the history going back to the creation of the auditor's office. But we also think that allowing state officers, just because they're mentioned in the Constitution, to sue each other is sort of a recipe for inefficient government where everybody's constantly suing each other. So there's a policy reason not to allow that. Third, to the
So should mandamus, though, Mr. Rose, be available for that? Just because it is non-discretionary, right? And should it be limitedly applied to the specific person seeking the redress, that person specifically? Should that be the basis for a suit?
I don't know if there's a good policy reason for allowing that. We haven't identified any constitutional or statutory basis for allowing that. And I think maybe that there's no reason for that to happen because in most cases, legal issues are sort of the purview of the Attorney General's office for the most part. And the Attorney General should be able to make that assessment in the first place before a suit is filed. And again, I mentioned in circumstances like the president, where there's some allegation that the Attorney General maybe shouldn't be qualified to make that decision, which we disagree with here as well. We think the Attorney General is dedicated to doing the right thing under Vermont law, and I think the court should presume that. But in some circumstances, there are other constraints on the Attorney General's ability to simply ignore the law, and there are constraints on similar constraints on other state officers' ability to ignore the law in carrying out their duties. And that's sort of the important part of this, again, is that we're dealing with the political branch of government and intergovernmental branch disputes. And I think the court should be very reluctant to get involved in the details of how one executive branch officer feels the other one is doing at their job.
Should this court overturn OneCare?
No, it should not, Your Honor.
And why not?
I think for the reasons that we've outlined in our brief, that OneCare is consistent with a long line of precedent and practice, showing that where the government intends for officers to be able to sue, it generally says so. That there is, since the auditor's office was created, its powers have been defined by statute, and we think this court was correct about that. When it looked at the issue in 2022, the court was correct about that when it looked at the issue in 1904 in the State v. Howard case. And so long as there has been an Attorney General, the Attorney General's office has been responsible. That was why the Attorney General's office was created, to create an ability for the government to file suits. And, to the extent that the auditor says, well, I mentioned in the Constitution, I have a constitutional power to audit. We don't think that resolves the question as to whether the auditor has a constitutional power to sue another executive branch officer. We don't think that follows naturally from that conclusion, even if there were a constitutional power to audit. And again, the auditor's audit function has always been established by statute as well, as this court recently held in the OneCare decision. And I'd like to touch briefly on the what the auditor has characterized as an attorney's fees issue in this case. And I think what we would characterize as the auditor's right to retain counsel outside the normal executive branch procurement process. We don't think that claim is squarely presented to this court as the Washington Superior Court held. There's been no claim in the complaint that would establish a right to secure counsel and pay that counsel using state funds outside of the normal procurement process. We think that that doing so is a pretty remarkable argument, in that any time an officer of the government felt that another wasn't doing his or her job, that officer could retain counsel, pay them, enter into any contract without the state-specific protections involved in the current procurement process, and have those fees paid. But again, we don't think that issue has been squarely raised here. It came up in the context of a Rule 54 motion for attorney's fees, and we don't think that's the right procedural vehicle here. There's no underlying substantive basis for an award of fees, which Rule 54 requires. Now, the auditor has said it's the Constitution, and I've explained why the Constitution itself says that there has to be an appropriation for funds, and the longstanding rule has been that the Secretary of Administration and the Commissioner of Finance control the expenditure of executive branch funds. And the auditor has also said that his contract with his outside counsel is the substantive basis of award for fees, but I don't think a party can rely on its own contract with its counsel under Rule 54 as for an award of fees, particularly from the state. So if there are no other questions, I would just conclude by asking the court to affirm the Superior Court's decision.
All right, thank you.
Thank you.
How much time does the appellant have, please?
Appellant has 5 minutes and 46 seconds remaining.
Counsel?
Thank you, Your Honor.
Mr. Byrne, can I start with a question?
Sure.
All right. I'd like to know your response to Mr. Rose's or the Attorney General's position that the issue is moot. And if it is, does the doctrine of mootness apply to it?
Is which issue moot?
The issue as to whether or not the Attorney General, or rather the auditor, has the right to sue, the inherent power to sue, the right to sue,
It's
and
absol-
retain counsel.
Right, it's absolutely not moot. I haven't been paid. I still haven't been paid. So the fact that I'm here is just because we believe that the case is very important. If the auditor is going to be able to do this in the future, you've got to be able to have a process where the auditor can retain counsel. It's also not moot because the Attorney General has consistently maintained that only the Attorney General can determine who can sue the Attorney General. That is an absolute violation of the due process, the equivalent of the due process clause in Vermont's Constitution, because the Attorney General can't make a decision about whether or not somebody can sue the Attorney General, and that's exactly what they've done here. I mean, in the printed case, in the attorney's fee printed case, it's at pages.
Well, that's what she said, but he did it and she did nothing about it. So why is it not moot? I mean, we're here because he sued the Attorney General.
Because their legal position is that the auditor can't do it. Right?
But he still did it and it happened. So why is it not moot?
Because mootness looks at whether there's a legal issue that's in dispute, not the practical consequences. And
Well, there has to be an ongoing issue about it, right?
there absolutely is an ongoing issue. The office continues to maintain that the auditor cannot sue the Attorney General. That's been their consistent position throughout the Superior Court and the Supreme Court.
And what harm has he suffered from her position right now?
Well, there's three different types of harm. One, there's the institutional harm to the Office of the Auditor of Accounts because it's infringing on his duties and he cannot complete his duties because he can't hire an attorney to get an answer on these legal questions. And as the Attorney General has said, their view is the auditor solely has statutory powers. So not only can he not hire an attorney to represent him in court, he can't hire an attorney to go to VPEC to get an answer, and he can't hire an attorney to provide him a private opinion or a public opinion about the questions of law that are squarely presented to the Attorney General. And these really are questions of law. They're not policy issues. Because if you look at the question that was asked to the Attorney General, is do bond premiums fall under the definition of financing in 24 VSA Section 1891(7)? That's a pure question of law. There is no policy question there. And the auditor takes no policy positions on these sorts of things. And it's unfortunate that the auditor's office has suffered institutional injury because immediately after the office introduced its report to the public sphere, the mayor of Burlington criticized the auditor for not being independent. So the office is suffering in the eyes of the people of the state of Vermont because there's an accusation that the auditor has not been independent. And that's a serious accusation for the auditor because he has a professional obligation to maintain independence. It's right in the GAGAS, it's right in his professional standards, and we've cited all those things in this case. So there's a serious injury there. In addition, the auditor is incurring interest, which is the traditional form, monetary harm is a traditional form of of harm under Article 3 doctrine about standing. And in addition, he's also suffering informational injury because he can't get an answer to the question, right? And that's well recognized in the case law that if you have informational injury, that's actual injury that makes the case not moot and gives the auditor standing for doing that. The audit is still incomplete, right? The audit is still incomplete to this day. And he cannot complete that audit without answer in some form or another to the questions that he's asked. And he can't answer it himself, right? The auditing standards say that the auditor, if it's outside their competence, they can't answer that question. That's why they need to get a lawyer to answer the question. And that's why the Attorney General needs to answer it. I mean, the statute is plain, right? It says they shall answer the questions of law. And it's important for the rule of law that the Attorney General of all offices follow the law, follow what the legislature told them to do, and provide answers to the written questions that were provided that the auditor needs to complete its job. Quickly, there's the other thing that, they said it's incorrect about, whether the record is incomplete as to whether there was ever a denial of legal services by the Attorney General. This case comes to this court on a motion to dismiss. The court must accept the allegations as true. The Attorney General is saying, don't look at the allegations, trust my representation. That is the complete opposite of the legal standard here. On paragraph 16 of our complaint, we said, in February 2023, the Office of the Attorney General informed the Office of the Auditor that it would no longer provide opinions to the Office of the Auditor of Accounts. Both Doug Hoffer and Timothy Ash attended that meeting. If this court accepts the Attorney General's representation, it is disregarding decades of its own precedent about how it's supposed to treat something on a motion to dismiss. The Attorney General's representations are not true, and we've alleged that. We should have an opportunity to explore that. Thank you.
Okay, thank you very much. Please call a conclusion here.
That concludes today's